Hello, sir.
Yes, sir.
How
Hello.
important is post-mortem report in case of murder or rape? Like, are they really successful? Do we have any scientific evidence which supports them? Please help us with this, sir.
See, there are many judgments of the Supreme Court of India. They say, like post-mortem reports are not substantive; they are only corroborative. But even if the doctor is deposing, who has done the post-mortem, rather than the report, what the doctor says has got more value, because in criminal jurisprudence, the oral evidence has got more value than any other form of evidence. So it is always like that. And even if you go to the deep into the, let us even take the example of VISCERA report, that is preserving organs. There is a judgment of Supreme Court which clearly states that the VISCERA reports are not conclusive. So even that cannot be taken into consideration always. So they are always corroborative. It's not substantive. That means they cannot be relied upon heavily. Okay, they will only support little bit the oral evidence, whatever you are trying to depose with your oral testimonies. Then coming back to the post-mortem, these post-mortem reports, why they are not substantive is, if a person dies, he can die only based on two aspects. Anybody in the world, you might have checked. So whatever disease may come to a person, he will die only with two reasons. Even if he is killed also, a person has to die either with cardiac arrest when his heart stops, or else he has to be brain dead. Okay, only two reasons are there. There is no third reason. If the kidneys fail, also the person will not die immediately. If the lungs fail, also it will take some time. The heartbeat has to stop. It ultimately lead to a cardiac arrest. So even if there are a lot of post-mortem reports when a person has been shot dead or stabbed to death, or even has been throttled to death, or whatever force you use to kill a person, or poisoned to death, in any of these cases, it will ultimately mention that either there are internal injuries to a person, ultimately the person has died with cardiac arrest only, or else by way of brain dead. So even if you're shot dead, a person is getting cardiac arrest is being written in the post-mortem report. So what way it will the defense lawyer will claim that it has clearly states that cardiac arrest. But the reason for cardiac arrest is a bullet injury or a blunt injury or throttling the neck or whatever, or just piercing somebody and he has lost lot of blood, bleeding injury, and he has ultimately died. Or else you have bet a person, for example, and he was a weak person. He was taken to a hospital after few days, or in coma or semi-coma, or after a month or so he has died. Then a case of culpable homicide has been booked. So even such kind of scenarios also, as I told you, ultimately the post-mortem report will not reveal anything more than cardiac arrest or brain dead. So if you are trying to hunt more reasons in that, then that is pure foolishness. Even earlier, it was not taken into consideration because the IPC was the CRPC did not have any such kind of provisions for scientific and medical evidence. But now some changes have been brought into the BNSS. But still, it depends on case and facts and circumstances of every case. And the role of lawyers is about the interpretation of the judgments. When there are binding precedents of the Supreme Court in the form of judgments which clearly says that post-mortem reports, the viscera reports, all these are not substantive, then that law is already laid down. So you cannot rely totally on that. And another example is, if you talk about the POXO cases or rape cases, lot of advocates and police officers think that they stress more on the medical reports and all. But ultimately, the testimony of the female, the girl victim, is more than sufficient. The minor girl or a major girl is sufficient to convict the culprit. So that is the rule of law. Neither there is a need for the doctor's evidence, the medical evidence, the doctor's testimony, or any other witnesses and all. These things are all secondary. They are only corroborative. The substantive is only the victim statement. And there was a hearing in the Telangana High Court. One of the advocates in a rape case said to the Honorable Justice, addressing Lordship, said, this case has to be quashed, this rape case. There is not even a single eyewitness. Then immediately Lordship said, what do you mean? Why do you get in a rape case? How can you find an eyewitness? So that is because people will discreetly do that kind of heinous act. So the last thing that a rape case can have is an eyewitness. Very rare. So it will only have circumstantial evidence. Either the murder cases mostly will have circumstantial, so that is binding. Or you have like the motive and all, these have to be established. So the motive also includes, as per the Evidence Act, like the section 8, the previous subsequent conducts and the preparation, all these are very important to prove a crime. So no motive, no crime can be proved. So any case, particularly in the heinous crimes, so end of the day, so what matters is the oral evidence, not the scientific. It corroborates, because there are a lot of lie detector and even narco analysis tests are also not binding. So the courts will not, they will allow you, but if the accused has to give consent, if the accused do not give consent, then it cannot be imposed upon him. So even if he is giving consent, even if it is, the result is against him, it cannot be used against him in the court of law, because Indian criminal jurisprudence is more of the forms of evidence. What I told you, there is a lot of evidence, importance for the oral evidence.
Thank you, sir.
Thank you.